there are two cases, one involving the FTC,
Right.
Slaughter, the other involving the Fed,
Right.
Cook. Cook is not Slaughter.
Right.
They've changed their view. They initially claimed, as you said, that they had the right to, because
Right.
somebody works for the executive,
Yeah.
he is the head of the executive, therefore he has the right to terminate them because they are in essence exercising his power by delegation. They tried that with Cook, and there was dictum in an opinion by the Supreme Court that said we think the Fed is different, largely because they do some things that are not executive, and they switched their basis to cause. The cause being supposedly misstating the value of
a house,
misstating the value of the house, or misstating that
mortgage fraud,
principal residence, whereas it wasn't. I think she corrected it later on, didn't she?
She did.
Yeah, but also the argument is this was a house and a tax return that preceded her term.
It preceded her term.
It had nothing to do
before she held office.
Right.
But that's what they're arguing in Cook.
So you're saying you think that it's possible the Supreme Court ultimately could rule in favor of Cook,
absolutely,
even though not in favor of the general principle of the other agencies, treating the Federal Reserve differently. Melissa?
Well, so first of all, these independent agencies are structured by Congress. They're created by Congress. They're meant to be independent for a particular purpose because the work that they do should not be swayed by political whims. So they are purposely structured by Congress to be insulated from partisanship. They have bipartisan membership on their boards. It is the reason why there are limits that Congress imposes on their ability to be removed by the president. And to be very clear, this president wants to be able to control the entire executive branch and to prosecute whatever agenda he has for the work that it does. And the fact of individuals within these agencies who may object to that agenda is an impediment, and he's moving to eliminate those impediments. Rebecca Slaughter, who is the commissioner of the FTC, who was removed, and the Supreme Court allowed her removal on the shadow docket. We should talk about the shadow. We'll get to that. Rebecca Slaughter was part of a body that was literally suing organizations like Amazon and Meta and Facebook and Twitter and TikTok for consumer issues, all kinds of things. These are the same people standing behind the president at the inauguration. There's a reason why they're
paid for it.
Well, there's a reason they're supporting him, and there's a reason that this is part of his agenda, and there's a reason why Becca Slaughter doesn't have a job now. Lisa Cook's job is an entirely different thing. You're right that the Supreme Court said earlier in Selah Law, a case from 2019, that the Fed is different. They didn't exactly articulate why the Fed is different. There were words.
Well, different in the sense that it requires its independence.
Different in the sense that the justices have retirement accounts. That's what makes the Fed different. That messing with the Fed has the potential to completely blow the economy, and even the justices recognize that.
Trump.
So I'm in some of these cases.
I think it goes a bit far. I really do. The Fed does things that are not executive.
Fully understand that, but this court has never respected those distinctions in independent agencies. What they do, I think, respect is the fact that the Fed is so inextricably linked to a proper and functioning economy.
I think once you go down the judge's path, though, I agree with you descriptively. I think this is where it's going to come out, that Slaughter loses, but that Cook wins because the Fed is different. But I think Professor Murray's right that it's very hard to distinguish the Fed from, for example, one of my clients, the head of the Merit Systems Protection Board, which is, I think the Fed is far more executive in nature than the head of the Merit Systems Protection Board. The other thing I'd say about these cases, though, there's a bigger thing at issue. It's not just the leadership and in these agencies. It's also the career staff. To me, the great thing about working at the Justice Department was that I had a totally bipartisan staff of people who were experts in all sorts of nooks and crannies of the federal government. And I'd often come in with an impulse, and it might have even been an ideological one, and they would tell me why I was wrong. And that happened to me every week. I mean, and it was the best part of the job, honestly, because that's what yields good decision making. And when you've got a president who is bent on trying to fire all the career staff, forget about just the heads, but all the career staffs of these agencies, and replace it with loyalists, you do really have the problem that the 1883 Pendleton Act was all about, which is trying to get a true civil service that's nonpartisan, full of experts.
And make better
we're
decisions.
giving that up.
And the verticality of his reach is, I think, is unprecedented. And we could go back to the spoils system that was supposedly eliminated.
Boss Tweed.
19th century. Yeah.
Boss Tweed, New Yorkers. Do you think that Trump versus the United States, from 2 terms of the Supreme Court cases, not last term, the term before, this is the one that argued that the president has presumptive immunity for official acts, and even if it's official acts, even the outer contours of those acts, if it's part of within the scope of his responsibility, there's no criminal responsibility. So the argument is, did he get emboldened by that? Do you think that that Supreme Court decision had an effect on him, or it wouldn't have mattered? He would have done this anyway. Because you get a sense, and I know that Melissa, who we'll talk later about her recent law review article that just is coming out in Northwestern Law Review, but the idea that he, in his defiance of lower court decisions, he seems to think that he will win before the Supreme Court most of the time. So I can just ignore like the judge that said, don't send off the 250 Venezuelans to El Salvador. Don't send them off. And if you send them on a plane, send them back. And he said, nah. And it's perhaps because he thinks the Supreme Court would never make me do that.
Well, I don't read minds. And if I did, I wouldn't start with his. But I don't think it emboldened him with respect to acts like that, which he has lost consistently on in the lower courts, despite his, or maybe because in part of his abuse of lower court judges who render those decisions. And there are 4 cases coming up to the Supreme Court that he could conceivably lose.
Right. Tariffs
being one of them. Arrests under the criminal alien statute.
Alien Enemies Act.
Right.
We're about to talk about that.
Yeah. And
birthright citizenship.
Birthright citizenship, of course.
And the firing.
And the firing of
those are the 4.
Those are the 4. And interestingly, in an exchange in the birthright citizenship case, 5 separate justices asked the solicitor, each in different ways, whether the administration would respect the decision of the court. I don't know of that ever happening, but 5 times he answered yes, they would. And in fact, they put in I've got it here someplace. They put in a footnote that the Solicitor General represented that the government will respect both the judgments, i.e. the outcome of the case, and the opinions of this court, which means the rationale for reaching that outcome. That, I think, is unprecedented in Supreme Court history. I don't know whether, I assume that Sauer and the Solicitor General anticipated that question and that he had clearance from the White House to give that answer. Now, whether it's going to hold for after the bad news comes in is something else again, but that is an unprecedented representation.
I just want to make sure that the room and the people at home know what we're talking. The birthright citizenship case is one of the executive orders that said if you are a child of someone who is here illegally, or even if you're here, I think, on a temporary visa, you do not get automatic citizenship for your child. That the 14th Amendment's birthright citizenship clause was established, Trump keeps saying this, it's for the children of former slaves. He keeps saying for children. He seems to ignore that, 1898, there was a Chinese person who was born here, and then he went to China, came back, and then the Supreme Court ultimately said, he's a citizen, he was born here. But Donald Trump has decided to say, well, it's really the 14th Amendment. That comes out of, that's essentially a Reconstruction Amendment, and it's only for former slaves. So the argument there is he might not care, right, what the Supreme Court said.
These are 2 different cases, though. So the case to which you're referring is now pending before the court, and they're going to hear oral argument. That's on the merits of whether Section 1 of the 14th Amendment, which confers birthright citizenship, says what it says. And I don't know. I can read. I think it says what it says. The case to which Judge Mukasey is referring is about that executive order rescinding birthright citizenship, but it's about a narrower procedural question as to whether or not district courts can issue nationwide injunctions.
Well, that's from last year.
Right, but this is where the
Right.
footnote
I know.
was.
I just
right.
want to make
so
sure.
just to be clear.
Yeah, to be clear, that's from last year's
But
decision.
the footnote encompasses much more.
For sure, but I think the most unprecedented part of the footnote is that John Sauer refused to say he would obey the lower federal courts. He was pressed repeatedly at oral argument on that question. He refused to say he would respect the decisions of district courts or intermediate appellate courts. He did say, I guess grudgingly, I don't know, that he would respect the United States Supreme Court, but that's not the whole judiciary.
The answers didn't sound grudging. And yes, they have played fast and loose with the decisions of lower courts, not just not respecting them, but persisting in the conduct that they were engaged in, but changing what the legal basis is for it. Judge says, you're not allowed to do that because you're relying on X. And they continue to do that and say, no, now we're relying on Y.
But that's such a huge breach.
is done.
I mean, this
Yes.
is what Neil is talking about. Like, you would never have seen Neil or Elena Kagan or even Thurgood Marshall, as Solicitor General, doing anything like that.
Right. Or even me, I argued one case.
So well. It was so good.
He's trying to catch up to Neil.
Before we
I'm one for one.
Before we move on, I just do want to say a word about Trump versus United States.
Good.
The decision that I think, I'm a fan of the Chief Justice, but it was, I think, his lowest moment. The idea that saying that the Constitution confers an immunity on the president for his actions. I do think it's a dangerous, reckless decision. For someone like me, who's an originalist, I don't see that anywhere in the original understanding of the Constitution. Indeed, the majority didn't even try and put it there. And I do think that decision will not live. I think that decision will be overturned because it is so fundamentally un-American. It is a betrayal of what I started with, the constitutional vision, divided power.
Interestingly, that even the impeachment clause, which provides for the removal of the president, says that criminal acts, which may be the subject of impeachment, can be punished in the criminal courts after he's removed.
Right, as if it contemplates the possibility of
Correct.